For the record's continuation, State of Tennessee versus Tremaine Wilbourn, docket numbers 1600515. Mr. Ganguly, Ms. Pastor, Ms. Hall are present. Mr. Wilbourn, Mr. Henderson, Ms. Dwyer, and Ms. Bird are present for the state. The jury has reported to the deputy they have reached a unanimous verdict on this case. Is everyone ready to receive the verdict of this jury?
Yes, sir.
For those family members that are here from Mr. Wilbourn, what this verdict is, you and I will find out about it in just a few minutes. But I'm going to require everyone to respect the verdict of the jury. You cannot have any emotion, cannot show any emotions, whether it's good or bad and different. You must respect the verdict of the jury, cannot show any emotions at all. If there's anyone here who feel they cannot follow that court's instruction, please leave the courtroom at this point, because it cannot allow any emotions to be shown once this verdict is in fact published. Deputy Smith, you can bring the jury, please, sir.
Yes, sir.
Thank you, ladies and gentlemen. They want to be seated. Ladies and gentlemen, the jury that Smith has reported to the court that you have indicated that you reached a unanimous verdict on this case. Do all of your members indicate that you have in fact reached a unanimous verdict?
Yes.
Let the record reflect that all the members, I have all the members of the jury have responded in affirmative. Ms. Miller Smith, if you can hand that jacket, trial jacket, Deputy Smith for me, please, ma'am. Thank you, Deputy Smith.
Welcome to this conference.
And this verdict reads as follows: State of Tennessee versus Tremaine Wilbourn, docket number 1600515, count 1. We, the jury, find the defendant guilty of first-degree murder as charged in count 1 of the indictment. Count 2, we, the jury, find the defendant guilty of carjacking as charged in count 2 of the indictment. Count 3, we, the jury, find the defendant guilty of possession of a firearm during the commission of or attempt to commit carjacking as included in count 3 of the indictment. Count 4, we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 4 of the indictment. Ms. Miller, Ms. Miller Smith, is this your verdict, ma'am?
Yes, sir.
Mr. Meadows, is this your verdict, sir?
Yes, sir.
Ms. Strong, is this your verdict, ma'am? Mr. White, is this your verdict, sir?
Yes, Your Honor.
Ms. Shaw, is this your verdict, ma'am?
Yes, sir.
Mr. Thomas, is this your verdict, sir?
Yes, Your Honor.
Ms. Freeman, is this your verdict, ma'am?
Yes, Your Honor.
Mr. Hill, is this your verdict, sir?
Yes, sir.
Mr. Clay, is this your verdict, sir?
Yes, sir.
Ms. Christian, is this your verdict, ma'am?
Yes, Your Honor.
Mr. Williams, is this your verdict, sir?
Yes, sir.
And Ms. Thomas, is this your verdict, sir?
Yes, sir.
Ms. Thompson, I apologize to you, sir. Is this your verdict, sir?
Yes, sir.
Thank you, ladies and gentlemen of the jury. Ladies and gentlemen of the jury, I'm told by Deputy Smith that your lunch is here. We're going to take a lunch recess for about an hour and 30 minutes. It is 12:14. We'll resume at 1:45. What I told you on Monday and Tuesday and all week, if you found Mr. Wilbourn guilty of first-degree murder, we'll have a separate sentencing hearing. You make a determination as to what the sentence should be on count 1, the first-degree murder case, and that is either life in prison without possibility of parole or the death penalty. So we'll resume in 1 hour and 30 minutes to give the lawyers a chance to marshal together any proof that they need to have presented at that sentencing hearing, and we'll proceed with sentencing at 1:45. You still cannot discuss the case amongst yourselves with anyone else, and that should give you enough time also to step outside of the building and get some fresh air, and your lunch should be here. You follow Deputy Smith. I see an hour and 30 minutes. Thank you all. We're going to jury of your peers, having deliberated on this case and having found you guilty of first-degree murder as charged in count 1 of this indictment, and the jury having found you guilty of carjacking as charged in count 2 of the indictment, the jury having found you guilty of possessing a firearm in the commission of a dangerous felony offense to which carjacking as included in count 3 of the indictment, The jury having found you guilty of being a convicted felon in possession of a firearm as charged in count 4 of the indictment. Mr. Wilbourn, in this judgment of this court that you are guilty. This court, as 13th juror, does affirm the verdict that the jury has reached in this case, and the court finds that there is more than enough evidence that any rational, reasonable trier of fact could have, in fact, should have found you guilty of the offenses as indicted in counts 1 and 2 and 4, and that's included in count 3. And this court does affirm the verdict that the jury has reached in this case. If there's a bond that has been set in this case pursuant to Tennessee Statute 40-35-115, we're going to order that any bonds that have been previously set in this case will be revoked, and Mr. Wilbourn rather will be detained without a bond pending further proceedings on this case. State, do you anticipate presenting additional proof at sentencing?
Yes, Your Honor.
How many witnesses do you anticipate, Mr. Lawyer?
4.
Mr. Wilbourn anticipate presenting additional proof at sentencing?
We do, Your Honor.
And all the witnesses, how many witnesses, Ms. Gangle? I'm sorry.
It would be at least 4. Your Honor, if they're unavailable this afternoon, then we have until Monday morning to get them here.
Ms. Gangle, if they're unavailable, we'll certainly give you some money to make sure that Mr. Wilbourn has all the mitigation proof that he needs to be presented. So if they're not available this afternoon, we'll certainly resume the sentence. Witnesses that you can hear today. If not, we'll finish the sentencing hearing on Monday. And Mr. Gangle, I know you probably have, but if you have filed notice of mitigating factors, if you have a copy for the court's consideration, I'll start blending that into a sentencing charge also. Anything else we need to address before we take a lunch recess?
No, Your Honor.
This court will stand in recess until 1:45 p.m.
All rise. The court stands in recess at 1:45 p.m.
Mr. Wilbourn, step into the body. Your lawyers will talk to you about Mr. Wilbourn. Mr. Wilbourn, I can't answer that question right now. Talk to your lawyers. Now, if you talk to your lawyers, if there's something you need to ask me, I'll be glad to talk to you, but it's really not a good idea to ask anything until you talk to your lawyers first. And I'll be glad to talk to you, sir.